Hey, welcome to Marketing Monday. My name is Natalie. Today I want to talk about 7 things that mediators should think about to protect their content. Now, full disclaimer, I am sharing general information here. I'm not providing legal advice. If you've got specific questions, consult an attorney always. All right. So, general information, not legal advice from me. But I've made a list of 7 things that I think mediators should think about to protect their content. Number one, why should you even care about the intellectual property? Well, let's be honest. As mediators, our bread and butter is facilitating dialogue, resolving conflicts, helping people find common ground. We all know what that is. But in this digital age, the materials that we create in order to put our name out to prospective clients and parties, like blog posts and ebooks, your brand ID, your brand logos, maybe your PowerPoint presentations in a webinar, all of your marketing content. These are all forms of intellectual property that can be copied, shared, and sometimes sadly misused by others if we're not careful. And the reason I bring this up is that we recently had a guest on Will Work for Food. You can find more about those programs at willworkforfood.news. And it was requested that she share her PowerPoint slides with the attendees. She said no, she wouldn't be able to do that. She had previously openly shared her PowerPoint presentation, and a colleague of hers just copied it verbatim, put his own brand on the PowerPoint slides, and then put it forward as his own. Not cool, right? So there are some different core types of intellectual property. Again, not legal advice, just my opinion. But the first is a copyright. And a copyright covers original works of authorship, written materials, blog posts, images, videos, and even workshop slides, like I was talking about. Now, why this matters for mediators is because your mediation guides, your checklists, your blog articles, your ebooks, they all fall under the copyright protection automatically when you create them. But you should think about maybe registering your work with the U.S. Copyright Office or the Copyright Office in your jurisdiction. And that can offer some additional legal benefit if you ever need to enforce your rights in court. There's also trademark. Trademark covers names, logos, slogans or taglines, brand identifiers used in commerce. Why does this matter for mediators? Because if you've developed a distinctive name, a logo, or a tagline, you might want to consider trademark registration through the U.S. Patent and Trademark Office. A real life example would be if you branded yourself as, quote unquote, the peaceful path mediator, and a competitor starts using that same name, a trademark can help you to protect your brand identity. Next, under our list of core IP issues that we want to take care of are trade secrets. This is the confidential information that gives you a competitive edge. This would be things like client lists, maybe certain workflows, or unique negotiation strategies that you've developed. And this is a little bit less common for mediators or mediation practice, but you still want to ensure that your sensitive business information remains confidential, especially if you have staff or external contractors. Third thing that we should think about in our list of 7 are just some sort of common scenarios where mediators need IP protection. And that would be publishing online content. Again, blogs, ebooks, educational videos. If you're posting them on your site, you want to ensure that nobody can rip them off. Your branding, your marketing materials, your name, your logo, your tagline, maybe even your color schemes that are part of your brand. You also would want to protect your workshops, of course, and your courses if you produce those. So if you conduct trainings or webinars, you maybe have slide decks or handouts that you would prefer not be copied without permission. right? Also, if you are collaborating with a colleague, so if you're co-authoring an article or teaming up with another mediator, it's really important to clarify who owns the resulting content. Number 4 on our list of 7, there are some simple ways to protect your content. One, you can always use the copyright notices and disclaimers. You just place the little C with the circle around it with the year, your name, your company name at the bottom of your website, on ebooks or on workshop slides. This can help because it reminds people that you are claiming copyright ownership. This doesn't magically stop all copying, but it does serve as a deterrent and will help if there's ever an issue or a dispute. There are some trademark sort of key brand elements. So if you have a practice name or logo that sets you apart, you might consider registering it with the USPTO. This is the official registration, and it does provide some pretty strong legal foundation if you need to stop someone else from using your brand. And then there's also a tool that is a watermark, or maybe you could limit distribution. So maybe for sensitive PDFs or documents, you can add a subtle watermark or limit the number of downloads behind a user login. This will help. It doesn't make theft impossible, but it does discourage casual content lifting, and it helps identify who might have leaked your materials into the world. You do want to be sure that you put terms of use on your website. So you might consider posting on your website a quote terms of use, and this outlines how visitors and clients can and cannot use your content. You can, use a resource like Termly or Rocket Lawyer. They can help you to generate sort of the basic terms and conditions. Again, not legal advice, just a starting point. And this will set expectations right away, clear, brief, and it gives you grounds to act if someone blatantly violates those terms. Now, what to do if someone steals your content? Well, you can always go with the, cease and desist approach. Fairly often, a really polite but firm cease and desist letter drafted by an attorney can resolve the issue pretty quickly. A lot of people just don't know that they are too close to your content and they put it out there. They just don't do the research. If it's on a public platform, a blog or social media, you might consider using a DMCA takedown notice. You can learn more about that at U.S. Copyright Office DMCA page. And then, of course, you always want to document everything. So take screenshots, note the dates, save the URLs. If it escalates, you will need that evidence. Remember, sometimes, again, people just don't realize that they're infringing. And so most often a really cordial email pointing out the problem can be enough to fix it. Use your mediator skills, communicate. Then there's a 6th on my list, which is handling your client's confidential information. A lot of us maybe wouldn't have thought to put this under this IP umbrella because it isn't strictly IP, but it is closely related to protection and privacy. So your client agreements and confidentiality, I think that's the primary space for this, but you want to make sure that your client intake forms, any mediation agreements clearly outline that you maintain confidentiality, but also that your materials, like handouts that you give them, remain yours. And data protection. If you store private documents digitally, ensure that you're using secure platforms like encrypted cloud storage or password protected PDFs, for example. Number 7, bring it all together. Don't stress out. Protecting your IP might sound like a big, complicated task, but it really comes down to just a few easy steps. Identify what aspects of your brand or content you need to safeguard. Then register or label your materials, copyright, trademark where relevant. Post the disclaimers, the notices, the terms of use so that people know that your work is protected. And then occasionally you want to monitor what you've created. Google your own content to see if it's popping up somewhere else without your knowledge. And if that happens, you want to act promptly if you find that infringement. And again, a really polite request frequently solves the issue. So again, these tips are meant to give you a sense of direction. They are not legal counsel, and every mediator's situation is unique. So if you're grappling with a serious issue or planning a big branding push, it might be worth chatting with an attorney. You know, as mediators, again, we pour our hearts out into creating unique guides and articles and branding elements to better serve our clients in our industry, whether they're corporate counsel or municipalities, first timers exploring mediation, what have you. It doesn't make any difference. Taking a few steps to protect your intellectual property can save you a ton of headache and possibly lots of legal bills further down the line. Plus, it underscores your professionalism and the value that you place on your work and that others should too and respect. So claim what's yours, keep an eye out for misuse, have a basic plan to handle any hiccups that should arise. You've worked hard to build your mediation practice. Don't let your materials or your brand be taken advantage of in the digital world. That is it for me on Marketing Monday. I hope your week is off to a great start. If you have any questions, problems, requests, or a topic that you want me to cover in a future Marketing Monday, be sure you let me know and I'll create a video just for you. Thanks for watching. Be good humans. Bye-bye.